Coach Renee, could you please start us off with the introductions by introducing yourself?
Are you talking to me, Dr. Ravi?
So I started with Renee.
Renee Bolio Banks, Indigenous Cause, and Zibikwe Indigu, that's my spirit name, and my English name is Renee Bolio Banks. Nice to be here.
Thank you. And Renee is our elder in residence. I'm Dr. Kari Rabi. I'm the physician here at the Native American Community Clinic in Family Practice and Addiction Medicine, and I run our MAT program. Michelle, would you introduce yourself?
Absolutely. Welcome, everybody. I'm Michelle Corcoran. I am the MAT nurse manager here at NAC.
Thank you. Megwitch, Deanna?
I am Deanna Bauer, the project coordinator for the Midwest Tribal Echo. Welcome.
Megwitch. Austin, would you please introduce yourself?
All right, hello, I'm Austin Needham, English name, spirit name, Ogama Mikanak, Indigenous Cause, Mukwan, and Dode. I'm from Red Lake, Minnesota, or Redby, Minnesota, Red Lake Band.
Megwitch, thank you. And I'm just going to go through the Hollywood Squares here. Stephanie?
Hello, my name is Stephanie Gay, and I actually live in Oklahoma. I work for the Oklahoma Department of Mental Health and Substance Abuse Services. I work with the opioid grants, and I am new to this position, and I'm getting started working with our tribal communities with their tribal opioid response grants. And so I'm just trying to gather as much information as I can to help me be better prepared.
Megwitch, thanks for joining us.
Thank you.
Thank you. Tina?
Hi, I'm Tina. I'm one of the advocates here at NAC.
Megwitch. Sam?
Oh, just want to say thank you for having us today. My name is Sam. I'm one of the patient advocates also for Native American Community Clinic.
Megwitch. Catherine?
Sorry, this is Kathleen Evans. I didn't realize it said Catherine up there. I do a Suboxone clinic in Walker, Minnesota. And so I see a lot of Indigenous folks from mostly Leech Lake and Red Lake, and some from White Earth as well. And so this echo conflicts with another one that I like to participate in. So I kind of look at the topics, and this one definitely is right up my alley today. So thank you.
Megwitch, thank you for joining us. Haley?
Hey everybody, my name is Haley. I'm public health analyst for the CDC's Overdose Response Strategy team.
Thank you for joining us again. Jim, nice to see you.
Yeah, what's going on, everyone? It's good to see you all. Hanono Gohaisi Yazo. What I just said is my name in Cayuga. My English name obviously is Jim. And I am a citizen of the Seneca Cayuga Nation of Oklahoma. I am currently working for the Iowa Tribe of Oklahoma, Perkins Family Clinic, and in behavioral health under the Tribal Opioid Overdose Prevention Grant. So good to see you all.
Megwitch. Angie?
Hi, I'm Angie Gingrich, and I'm a behavioral health clinician with the Nato Sub-Huron Band in Michigan.
Megwitch. Simone?
Hi, I'm Simone Megas Harmison. I am the NAC Red Lake Tribal Health Program Manager, IOP.
Megwitch. Jack?
Hi, I'm Jack Loftus. I'm a alcohol and drug counselor in the NAC Red Lake Tribal Health Programs.
Megwitch. Christine?
Hi, I'm Christina. I'm a part of the Suboxone program here at NAC and also do intakes for the IOP and Suboxone program. Welcome, everyone. Hi.
Megwitch. Jared?
Sorry, ill-prepared to not unmute myself. Bonjour, Anine, Jared Dunlap, Indigenous Cause. I'm, oh gosh, the light's hitting me wrong. I'm NAC's data analyst and eager and always willing to join conversations. My background's in public health And I find it very important to best inform how data is viewed and applied based off our health. So happy to be here today. Miigwech.
Miigwech. Zoe?
Hi, everyone. My name is Zoe. I'm one of the MAT RNs here at NAC.
Miigwech. And then I'm sorry, I don't see a name. I'll just, the young lady with the longer hair. Sorry, I know that could be anybody. I'll just keep going. George?
Hey, good morning, everyone. Or no, good afternoon. George Gonkalay with the Minnesota Chippewa Tribe. I'm the Human Services Director. I don't always sit in on these echoes as well, but I looked at the topic today, and it is a very interesting topic, and I'm excited about listening in and maybe even contributing. Miigwech.
Miigwech, thank you for joining us. Mackenzie?
Hi, my name is Mackenzie. I'm one of the patient advocates here at NAC.
Okay, Miigwech. Alyssa?
Hello, everybody. My name is Alyssa Benarchuk. I'm the Lower Sioux Healthcare Center Nurse Care Manager. We are in progress of setting up our own MAT program here for our community. Happy to be here.
Miigwech, we're excited to have you. Thanks for joining us. Charlie?
Anine, my name is Charlie Thayer, Indigenous Cause, Mukwan Dunam, Odawa Zagaining in Dujukba, Minneapolis and Da, Adi Thayer Ngoma, from LCO. I'm the ATOD coordinator at NAC, working with youth in the community. Nice to meet everyone.
Miigwech, Charlie. Rosemary?
Hey everybody, my name is Rosemary. I'm a nurse practitioner with Hennepin County's Healthcare for the Homeless program, focusing on buprenorphine for people who are unsheltered.
Miigwech, thank you for joining us, Rosemary. Jeremiah?
Hi, I'm Jeremiah. I'm a fourth year medical student at the University of Minnesota, and I'm working with Dr. Mary Owens at the American Indian and Minority Health Center at the Duluth campus to work on developing some more Native American healthcare curriculum for a broader context of our medical student population.
Miigwech, thank you. Abby?
This is Abby Anderson, PA up at Fond du Lac.
Miigwech, thank you for joining us. Rachel?
Hi, I'm Rachel Lukowski, the Behavioral Health Clinic Manager at NAC.
Thank you, Miigwech. Melissa? Melissa Gray?
Hi, Greg Ronnie with AICDC Withdrawal Management in Minneapolis. I occasionally on these, and as I think it was Jared pointed out that the topic was a big draw for me.
Miigwech, thank you for joining us. And Steve?
I'm Steve Slinsky. I'm a pediatrician with the University of Minnesota. And the topic caught my attention, so I'm to tune in today.
Miigwech, thank you for joining us. Melissa, is it Melissa? Melissa, are you able to introduce yourself? Melissa Gray? You can put in the chat if you're not able to talk. And then there's one other person who hasn't introduced themselves.
That might be me. Hi,
Yes.
I'm Dominique. Dominique from Gun Lake Tribe in Michigan. I'm the tribal social worker.
Okay, Miigwech, I'm sorry, I couldn't see your name, so I couldn't call on you. I apologize.
Oh, that's okay.
So I'm gonna go. Yes, now I can see it. It just popped up after you spoke. Thank you so
Okay,
much.
thanks.
Yep. So I'm gonna go ahead and start our PowerPoint here. Just bear with me for one moment. Okay. All right. There we go. So we are, as you all know, we are at the Midwest Tribal Echo. We've already had our prayer and land acknowledgements. We've done our introductions. This is the agenda. I'm going to run through the Zoom guidelines. Michelle will do our announcements. Then we'll have the presentation by Austin Needham, JD, and Michelle will bring a case presentation forward. And then we'll close and then have, of course, have questions after the presentation and after case presentation. As far as Zoom goes, let us know who you are. You can please introduce yourself in the chat function with your name, title, organization, and email. You can also update out your name on the screen if you right click, or I think some people, sometimes it's a ... you can rename yourself, and so everybody can see who you are, your name, and where you're from. And then just so that just as far as how this all works, we'd like it if you turn your camera on so we can see you. It just helps to facilitate discussion and so it lets things flow better. Please mute your microphone when you're not speaking. If we will mute your microphone if there's background noise or anything, please don't be offended. You can always turn it back on if you want to speak. Please use your chat or your hand raise function for attention, and in the question session, people a lot of times just speak up. And then as always, no protected health information, please. And I'm going to turn it over to Michelle for announcements.
Okay, so as usual, remind you, the first and third Wednesday of every month at noon, that's Central Standard Time. We've got some upcoming stuff, and if you see here on the 4th of November, we've decided to not have an echo. Day after the election, we were thinking maybe everybody would be a little preoccupied, so we're going to skip that. But on the 21st of this month, we do have Simone Megas Harmison, who is a program manager of the IOP Tribal Health Program here at NAC. She's going to be talking about Rule 25s and treatment, you know, referrals to a higher level of care, that sort of thing. And next slide. Case presentations, as always, feel free to send in any specific cases, success stories, things like that. We can talk about them or kind of discuss as a group in an upcoming session. You can get to that form at hennepinhealthcare.org. They have a specific area for the Midwest Tribal Echo on their page. Half and half buprenorphine waiver training, sorry. Half and half just means half in person, half online. And there is one coming up Thursday, October 29th from 1 to 5. It is free and it's available for physicians, PAs, nurse practitioners, and information for that is available again at the Hennepin Healthcare website. I noticed there's no CME slide. So one thing I want to mention, if you let us know who you are, where you're from, and what your email address is, then you will get an email at the end of the session with a link for a survey. You fill out the evaluation, and then that can help you get CME or CEU credit for attending the session. So just make sure that you let us know who you are for that reason. And now we'll turn it over to Austin, I think, right?
Yes, thank you, Michelle. So Austin will be talking to us about mandated reporting and ICWA, the basics. So I'm going to stop sharing and allow him to share his slide.
One moment. All right, can everybody see that?
Yes, thank you. Looks good.
Perfect. All right, so let's get started with the brief introduction, and we kind of already went through, but I'll just, so good afternoon. I'm Austin Needham. I'm an enrolled member of the Red Lake Nation, and I'm the new youth coordinator at the Native American Community Clinic in Minneapolis under the Office for Victims of Crimes, or OVC grant. So my title is officially the OVC Youth Coordinator. I'm a 36-year-old enrolled member of the Red Lake Nation. My more recent professional experience includes serving as associate judge for the Red Lake Nation Tribal Courts, assistant administrator of the Oshkosh Manitou Center, and ICWA liaison for the Minnesota Guardian Ad Litem Board, and a ton of other positions. My education includes a bachelor's in American Indian Studies from Bemidji State, a master's of jurisprudence in Indian law from the University of Tulsa, and a Juris Doctorate from the Mitchell Hamlin School of Law. Hopefully that helps boost a little bit of credibility, and I let you guys know I know a little bit of what I'm talking about. Let's see, so the OVC grant was awarded to NAC to better enable us to serve youth located in the urban American Indian community in Minneapolis who've been or are at risk of becoming victims of crime due to the opioid crisis. My role as the OVC Youth Coordinator is somewhat versatile, but primarily is oriented towards making efforts for and engaging in connecting systems, streamlining referrals, developing partnerships, as well as increasing and enabling youth access to behavioral health services, such as, or some examples would be our current efforts in school-based services in Minneapolis. We're here today just to briefly discuss mandated reporting, some important considerations and resources and links to training materials, which I'll provide at the end of on the last slide. We'll also go over the basics of the Indian Child Welfare Act, like very basics, some considerations regarding what we may be able to do to improve systems level response to potential child welfare or mandated reports. And finally, we'll tie it up with a few key takeaways and approximately 10 minutes for questions and answers. I just want to make a quick note, a disclaimer of sorts that, you know, with this presentation, I mean, it really is topical. So I would just encourage everyone to look into some of these topics more, to become more knowledgeable. I don't want people to walk away with the false impression that maybe we're more experienced in ICWA after the presentation than we should be. Any one of these topics could probably be a dissertation topic. So thank you for that. All right, getting started. So what is a mandated report? A mandated report is a legally mandated report of any suspicion of abuse or neglect of a child or vulnerable person to the authorities, usually your local child welfare agency or law enforcement, usually both. So where the reports will be submitted. So some states require all citizens report, while others vary or land somewhere in the middle. So I wasn't able to do a ton of research on what specific states offer in the Midwest, but according to Minnesota law, mandated reporters include people working or professionals and their delegates working with children to make mandated child protection reports if they know or have reason to believe a child or vulnerable person is being neglected or abused within the preceding 3 years. Now, that 3-year statute of limitations may vary depending on jurisdiction outside of Minnesota, so just be aware of that. And then I included a list of examples or professionals deemed mandated reporters in Minnesota, professionals, and that would include their delegates. So for the sake of time, we'll just breeze past that, but feel free to go ahead and glance at that. All right, so what to report? Ideally, the major things that you must report include neglect, physical abuse, sexual abuse, mental injury, and or threatened injury to a child or vulnerable person. The most important part of all is to remember, and to remember about information to provide is try to provide as much information as you can recall, as you can remember, as you can collect, and keeping in mind the statute of limitations in your jurisdiction. The more information that allows the social service agency or child protection team to make with a higher degree of accuracy the best possible determinations and decisions and plans for the child or children, families involved, the better. The more information they have as far as the allegations themselves, and even including information of like positive supports could be helpful. So on the right of the slide, you can also see that information that the agency will expect from you in the report. Most of the time when you're filing the mandated report in the form, all those questions will be on there and you'll gather it. Moving on, we have how and where to report. A verbal report is required within 24 hours, a written report within 72 hours, and those need to be submitted to the local social service agency and law enforcement. Mandated reporting laws generally legally obligate a person to make these reports of suspected or alleged abuse, but they also come with teeth. You know, the law has discipline and consequences on the other side, but there are also some protections for mandated reporters, and maybe arguably one of the most important is confidentiality of the reporter's identity when they make the report. This is preserved throughout the process. Also, employer retaliation is another action that's prohibited under the law. And I suppose there's many reasons this could be important, but what comes to mind for me would be circumstances in which maybe an employee of a facility was required to make a report against the facility or a staff member for alleged abuse or neglect. So what happens after a report's made? Well, a mandated report will receive the child protection response, which is essentially the set process in which a county or local agencies proceed with intake, screening, and assessment or potentially investigation of the child protection reports they receive. Essentially, this is the process in which I guess a report becomes a case or not. All right. Going back to the teeth that the law comes with. So there are consequences for failure to report and false reporting. In this slide, we have some examples or some of the penalties for failure to make a mandated report, and these are specific to Minnesota. I would check if you're outside of Minnesota for your local jurisdictions, laws, and policies and regulations. But they show that the government really wants this taken seriously, and probably because failing to make a mandated report can not only cost us as professionals our jobs or reputation, but there's also these serious legal consequences, including fines and or imprisonment. So furthermore, it's important because nobody wants to place any child or vulnerable person at risk of harm or victimization if we can at all prevent it. And making that report is the effort to help prevent that or determine if it's possible, I guess. Yeah. Moving on. In this slide, I just shared some statistics for the sake of time. We'll have to skip past it, but these are statistics on mandated reports in Minnesota. Feel free to come back and glance at them, and later we can share the PowerPoint, or I'm not sure. I believe this is being recorded. I didn't hit the record button though, so there'll be access to it if anyone wants it. I can also send an email. But something to note here on this slide is that the majority of mandated reports are being made by law enforcement and school personnel, and that's 39% of our reports. I just think that's significant. These are the people that are primarily entering in mandated reports and according to law in their profession. At least I hope. So keeping an eye on that, one of the things I think of, and I'm maybe getting ahead of myself, is what this ends up looking like with all our online schooling and stuff like that. So I'll mention that here a little bit later. All right, so this slide is obviously really loaded. I don't expect anyone to cover this right now. I just I wanted to share this excerpt from a Minnesota DHS report. I included it because it has some important and interesting stats. So just please feel free to come back and look at it and check it out. These are 2019 stats, and out of approximately 38,000 children. I won't go too much further, but the stats are really interesting and something that could be used later on to kind of weigh some of our efforts against and whatnot. We'll keep on moving. All right, ICWA enactment. So getting into the Indian Child Welfare Act, or ICWA, as many people refer to it as the act. ICWA was passed by the United States Congress in 1978, and it was passed and enacted in response to alarming rates of Native children removed and placed in non-Native foster placement, and with some acknowledgement of conditions set forth upon Native people in Indian country by the United States. So that through hundreds of years of federal Indian law policy failed, although President Nixon had already had admitted this a few years earlier in his address to Congress in support of the Self-Determination Act. But regardless, Congress took this opportunity to acknowledge this in this act and attempted to put law in place to correct racism and bias against Native children and families in the child protection system. And then also as an effort to prevent the loss of tribes' most important resource, our children, by further assimilation and identity loss, whether intentional or unintentional, direct or indirect. I included these next couple slides. I won't go through them in depth, but I saved these just so people could get an idea of what these 7 areas of Indian policy are. Because it's important to understand the history and the build up to ICWA for those of us who may not have the full expertise in that, but it's important to understand it, to understand why ICWA is important. And there's a lot of people out there, believe it or not, that don't share that consent about ICWA. And I guess my assessment is just a lack of knowledge and the purpose and intent of the law. So in this first slide, you know, we have some highlights of policy beginning in 1770s to the 1960s. And as you can see, like each policy generally includes some form of detriment to tribes and Native people. We have removal that consists of the several trails of tears, including the Cherokee and others, loss of ancestral homelands. We have the reservation systems, put in place more loss of land. We have further seclusion and isolation, assimilation, boarding schools, encroachment on inherent tribal sovereignty, the end of treaty making, and the enactment of the Major Crimes Act. And again, loss of even more land, almost the rest of it, right, with the Allotment Act. Indian reorganization, which is the era which the United States essentially said they wouldn't interfere with tribal self-government as long as the tribes do it the same way as the U.S. And then we have termination, the era in which the U.S. decided to basically pursue getting rid of tribes by pulling federal recognition, and which ultimately ended up being another terrible decision, impacting us long-term and yeah, to an unimaginable magnitude, I suppose. And this next slide is just the tie-up from the first here, and you'll see the self-determination era began, and it's our current era, arguably, I suppose, by some, approximately with the Indian Self-Determination Act, which was then followed by acts such as ICWA, our religious freedom, and it shocks me at a lot of times that this all only happened in the 1960s, right? 50, 60 years ago. But I like to look close and see and realize how much progress we as Native people and tribes have made in such a short period of time, especially after we received that support and we were able to self-govern, to exercise our inherent tribal sovereignty. I just think that's important to see. Moving on, we have disproportionality in ICWA, or prior to ICWA. So these are just some of the, that's okay. So prior to ICWA, as I mentioned earlier, there's an alarming disproportionality about a home placement of Indian children compared to white children and or non-Indian children. So again, for the sake of time, I'll just highlight and acknowledge that 85% of Native children placed out of home were placed in non-Indian homes prior to ICWA enactment. And just imagine that the magnitude of the long-term impacts that this potential loss of identity that these children suffered, and that loss of identity potentially lasting for generations after the one child. So it's frightening. You know, ICWA isn't a fix-all, but it definitely gives us tools to and support to be able to seek the best interests of our children, families, and people and tribes. So here on this slide here, we have the negative effects of foster care. And according to studies, kids placed in foster care are also placed at a higher risk of suffering from loss of culture and cultural ties, negative health outcomes, such as higher or elevated risk of disease or chronic disease, teen pregnancy, STDs, STIs, and HIV, as well as many various mental health concerns and suicide, and many more long-term impacts that very likely just help perpetuate this unending cycle of this trauma and injury for our people. All right, so in regard to ICWA, the spirit of the law, the spirit of ICWA, this is important. We touched on this a bit already, the spirit of ICWA in previous slides, but what's most important, I guess at this time, or in my opinion, to remember, not the only thing about ICWA or the spirit of ICWA, is that the intent behind the law is to ensure the best interests of the Indian child, family, and tribe are considered and protected throughout the ICWA case. Here, I just want to highlight the recognition by Congress that our children are our most vital resource to our continued existence and integrity as Indian tribes. That Congress acknowledges that the need exists for consideration of our unique cultural and social standards, and also the removals taking place at that time, especially at that time, were unwarranted, mostly due to a massive failure by non-Indian agencies to consider prevailing tribal, cultural, and social standards. The intent of the law what Congress enacted ICWA was for the law to protect the best interests of Indian children and promote the stability and security of Indian tribes. It's direct language from ICWA. And ICWA also serves as further recognition of tribal sovereignty, which I think is important generally for tribes in Indian country, and strengthening our sovereignty down the road to be able to refer back to this recognition by Congress. And it recognizes both by statute and implementation of the laws, as you'll hopefully see here in a few minutes. Okay, so yeah, it was also intended to eliminate or mitigate potential bias of state and county workers in cases involving Native children. Some ways this happens include tribal intervention, or the tribe's power to participate and intervene in the case at a level that it deems best, or in the best interest for that particular case, family, and whatnot. Those things change. There's a lot of considerations that I won't be able to discuss today that tribes need to make in order to determine what their best level of intervention and participation may be, just primarily due to a lack of resources and a massive demand that covers a large geographical area. So there's also tribally designated qualified expert witnesses who serve primarily to provide testimony in court. That's how they, but to provide testimony in court on behalf of the tribe at a crucial moment in a case, and the testimony is in regard to cultural and social norms within their tribe's communities. And then there's many other checks in place throughout the law that help Native people, our tribes, and our tribal social services get a leg back up in the court process and to look out for the best interests of our children, families, people. All right, so we'll just try to skim over this. I just want to make a quick note. Bureau of Indian Affairs provides regulations and guidance on ICWA and its implementation in courts across the country. There's a huge effort just not long ago, within the last 5 years, I don't have the date, but it's within the last few years that there was an effort to reinvigorate the language, update to the law and BIA regulations that was made an effort to increase consistency and implementation across the country in ICWA case, because there's a huge inconsistency, and I've witnessed a lot of that myself. But this information, the BIA regs and guidance, can be accessed on the BIA website. I believe I have some links there at the end that I'll also share again. Individual states, it's important to know, I think, also that individual states have this ability or authority to implement laws that enhance or improve ICWA as a federal law, or ICWA implementation within their states that's, I guess, justified by being geared uniquely to their individual circumstances that best serve. The important piece of states having this power is that they can do that so long as ICWA standards are not jeopardized or decreased in any way, or they're not compromised, or especially in any way that compromises the rights of families and tribes, or the tribe. All right, so in Minnesota, we have the Minnesota Indian Family Preservation Act, or what people often refer to as MIFPA. This does a great job. I won't go into MIFPA too much, and I know that we have attendees that are outside of Minnesota. Check with your state to see if you have something like that. I don't know all the states that do. I know Wisconsin has like WICWA, Oklahoma has one, I believe California either has or is working, I can't recall, but yeah, check it out wherever you're at. It's important to kind of know what your state's doing in those regards, and if you have influence, making sure that those things are actually accurately portrayed within the law. So lastly, you just mentioned the Minnesota Tribal State Agreement, which is unique, and it's not, but it's a standing agreement between the state of Minnesota and Minnesota tribes, essentially on how best to interpret and implement ICWA and MIFPA for our Native children and families within Minnesota. Take a look at it. Tribes and states are encouraged to enter in these agreements under ICWA and to kind of just enhance the implementation of the law within their jurisdictions. So next we have some of the primary definitions covered under ICWA. These are all important to know. I won't be able to get into them. It takes it'll take some analysis and then just breaking them apart and whatnot. But read through them. They're important to know. Indian child, tribal membership, Indian parent, Indian custodian, and Indian tribe within these definitions. And when people fall within these definitions, they receive certain protections and rights and privileges under ICWA, being an ICWA case. I would, though, just note that best interest is important because it's a standard that's typically monitored, measured, and used as a basis of decision-making in ICWA cases. All decisions that must be made in the best interests of the Indian child or children involved in the case. And according to ICWA, the child's best interests are intertwined with that of the tribes. That's important, and I can answer more on that in questions and answers later if people wish. Tribal intervention. So a big piece of tribal intervention, what gives us that power to intervene is tribal sovereignty. Sovereignty is essentially the power to self-govern as a nation or an independent nation. And this is important because there's so much depth that goes into the definition of sovereignty, its origins, and all the way to how it's implemented, exercised, and or recognized throughout the world, but especially uniquely within the United States, which is made up of 3 different sovereigns. And in order of existence, I list tribes, states, and then the federal government. Tribes were here first, then we had states, and the states joined union and made the federal government, right? So those are our 3 sovereigns, and some would argue that tribes have more sovereignty or a higher degree of sovereignty than even individual states, because the federal government has never engaged in treaty making with any individual state. We have hundreds or maybe thousands of treaties with tribes. U.S. government, as we all know, doesn't engage in treaties with tribes anymore, but they historically haven't engaged in treaties with any other nation but a sovereign nation. So sovereignty and jurisdiction also become intertwined and complexly so at times. Under ICWA, tribes have the sovereign power and jurisdiction to intervene and participate in ICWA cases for their members or eligible members in Minnesota. That language differs from ICWA, and that's one of the enhancements, right? Well, I won't go into that. We can discuss that later if we have time. Part of intervention, though, is the ability of tribes to determine their level of activity in monitoring or guiding the case while it's in state or district court. Or tribes or any other party in the court may request transfer to tribal court whenever they wish, actually. And tribes generally only do it on necessity and when maybe the state or district court is taking a route that doesn't work with the tribe's prevailing cultural and social norms. There's 2 distinct types of jurisdiction that exist in regard to tribal child protection: exclusive and concurrent jurisdiction. So in regard to exclusive, it is just as essentially as plain as it sounds, that either the state or the tribe may have exclusive jurisdiction over the case, but not both. It's exclusive of any other jurisdiction. ICWA cases generally fall under the concurrent jurisdiction, which is how tribes are able to exercise their jurisdictional powers within that state or district court. Becomes confusing and frustrating maybe for professionals working within that state or district court system that don't have a full understanding of the tribe's sovereign powers, because it just seems kind of unfair, right? So with that, I would also just mention that tribes enjoy the power of full faith and credit. This ensures that this mandates that states recognize tribal court orders outside of the reservation for ICWA cases. And then there's other circumstances outside of just child protection in ICWA cases that states have to respect that full faith and credit and give that to tribal court orders. We won't get into that today. All right, so when does ICWA apply? Well, ICWA should apply immediately, as soon as the case begins, as soon as there's any form of intervention, right? ICWA applies, well, there's a frequently encountered issue, well, several actually, but that stalls up ICWA application on an ICWA case. And that's the lack of or a delayed notification to an Indian child's tribe, which subsequently inhibits the ability for a timely tribal, culturally specific intervention in that ICWA case, right? Or that monitoring and oversight. This happens for many reasons, but one of the more common reasons that I've witnessed and heard of is because the agency or the court wasn't made aware of Indian status of the child or potential Indian status of the child early in the case. Some social workers are required to ask on first contact. And sometimes for some reasons, the information just doesn't get disclosed in time or for whatever reasons those are in cases, there's a delay and the tribe may not receive notification or be made aware of that case or that report going through court in time for them to intervene and provide that culturally specific guidance. So the agency, whatever local agency is pursuing the case and on the case is also charged with the responsibility of ensuring ICWA compliance. I'd also say though that it's essentially the job of everyone in the courtroom, and thus any party to the case may file a petition for non-compliance, and the tribe is considered a party to the case. But ultimately, it's very important for CPS. I just want to stress it's important for CPS to know or be made aware of a potential Indian status of the child under ICWA or MIFPA if you're in Minnesota. Both. All right. So ICWA standards. ICWA has been and is considered the gold standard of child welfare law, because many standards under ICWA could and are considered a higher standard than general child welfare cases. For instance, the burden of proof to prove a case or truth of allegations is elevated from clear and convincing evidence standards to beyond a reasonable doubt, which is used more commonly or all the time, I guess, within adult criminal law outside of court. Those standards of proof it's a very significant elevation, right? A beyond a reasonable doubt hits above that 95% of proof stat line, and clear and convincing evidence is somewhere, you know, above, I guess roughly, I'm just gonna guess 70-80%. The lowest would be a preponderance of evidence, which is just 51% of proof. All right, so active efforts is also, it's also another standard that's higher than it would be within general child welfare on cases, and in my experience there seems to be some confusion or maybe inconsistency amongst professionals working on the field of what active efforts truly entails on an ICWA case, and maybe rightfully so. It can be confusing, right? And I won't get into what active efforts essentially is, but it's essentially going, and compared to reasonable efforts, going above and beyond to help that family complete those case planning objectives and taking steps for reunification in a more active way by the case manager. Moving forward, what can you or we do, right? Well, I mean, this list can just continue to be brainstormed, but be more knowledgeable of mandated reporter laws in your area, what's required of you as a mandated reporter, take some trainings, access some resources if you haven't already, make accurate, timely mandated reports when necessary if you are a mandated reporter, especially in Minnesota. Report as much information as you're aware of as that's been reported to you that's pertinent to your report alleged abuse, neglect, the child's Indian status, which, as we mentioned earlier, would be super helpful to get that right upon the initial report before intake and screening for the agency. Report the strengths of the child or vulnerable person or the family caretaker, which would be like an Indian custodian or even just a relative placement. Information about parents and particularly father's info. This is commonly lacking or left out in child welfare cases, and there are, I guess, if a handful of times is too much, but there are more than that, far too many incidents where father's info is left out and the father has a delayed, similar to the tribe, may risk a delayed ability to participate in the case as a party. Seek out and advocate for cultural awareness training in your organization, support, promote that stuff, just becoming more knowledgeable, even if you are an expert, will be helpful in sharing that information and encouraging people to learn. What else? So do not exercise discretion that you may not be authorized by law. I know it can be frustrating to make the report in accordance with legal recommendations or the legal requirements. It can be frustrating to send that off and put that put that into the hands of maybe an agency you or others you know or work with may have concerns about dealing with that case in a way that is unbiased or it doesn't receive any unfair treatment. I know that can be tough, but the biggest piece is getting it in there for them to investigate, to screen, assess, and investigate as necessary to determine that the child is safe or the children are safe in the report. So with that, you're able to give them that notification of potential Indian status and allow for, or at least allow the tribe to justify their immediate intervention. Not that they need to justify it, it's just that if for some reason there's a delay that's outside of the tribe's fault or your fault as a reporter, and maybe that fault falls on the local agency and notification. Well, the tribe has that documented that they were aware and they should have notified them earlier. Things like that. I mean, I think it's just important to make sure that that stuff's in there. And finally, to tie it up, we have some important takeaways, and some are redundant and repetitive from the last slide or the other slides, obviously, takeaways. But all right, so essentially, be aware of mandated reporting laws and trainings in your jurisdiction. Reporting laws don't necessarily allow for discretion to report by the reporter if allegations fall within those statute of limitations and legally required aspects of the report. The local agency, intake or investigation department will make a determination after the report's made. They'll take it through their intake screening process and investigation if necessary. The local agency is responsible for ensuring ICWA compliance and must work collaboratively with the Indian child's tribe from the beginning of the case until case closure, the end. Also, recognize and remember the importance of personal and professional self-assessment and self-awareness of potential bias or lack of objectivity, to acknowledging, encouraging, and promoting self-awareness. I believe that's all I have right now. And our next slide is some of the resources, and I'll just take like 30 seconds to go over those quick. We have at the top, we have the National Indian Child Welfare Association, or NICWA. That's a great website. They serve and put on trainings nationwide for tribes and state agencies regarding ICWA. An ICWA application across, that's a great website. Look it up anytime you need a resource. They usually have either the resource or links to others, or other links that will lead you to that. The BIA, that is the ICWA regulations. That's super important. There's great language in there and how to get a better understanding of the statutory language of ICWA and how it should be implemented within district court. There's the Minnesota DHS website. They have a ton of Indian Child Welfare Act resources, mandated reporter. They have the actual mandated reporter training, and being that this is the main agency that would be monitoring your compliance as a mandated reporter, receive complaints if you didn't, if you failed to make a report, this would be the place. So I think their training is probably, I actually attended it. It's pretty good, it's short, straight to the point. But yeah, I would make sure and follow them. They're pretty solid resource. Like I said, I just shared some of the ICWA MIFPA resources, but they have a ton on there. There's a real handy ICWA desk guide that is, I have to look again to see if it's more specific to Minnesota and MIFPA. I think it is, but maybe your state has something like that. If you're not in Minnesota, I would check it out with your Department of Human Services. And then also we have the Minnesota Children's Justice Initiative, who has their ICWA unit and committee and subcommittees, but they present trainings, materials, and resources. And for a very long time, they were, for the most part, I think the leading ICWA training entity for courts, for state courts and tribes and social workers, guardians ad litem. All right, so thank you for that. And I'm not sure, I might have missed a couple things, but we'll open it up for questions unless there's anything else.
Miigwech,
So
thank you
this
very
is
much.
Jared.
Also,
Oh,
could
Terry, go
you
ahead.
could you just stop sharing your screen so people can see each other?
Yep.
There you go. Thank you. Miigwech.
I didn't know if it was open to ask questions, if we're going in within the chat or.
Let's go to the questions. Go ahead, Jared.
Great. Awesome. Thanks for that. It was plenty of information there. Just knowing the special relationship of the Minnesota Chippewa tribe, if you have a child within, say, Leech Lake, who is a member of Fond du Lac, but they're, say, one of their parents, so say one of their parents is Leech Lake Band, and one of their parents is Fond du Lac, they hold membership within Fond du Lac, but they live in Leech Lake, if you're following me there. If it's reported, is the local agency Leech Lake and has responsibility over following through with that ICWA case, or would the child's band within the Minnesota Chippewa tribe, say Fond du Lac, would they intervene? how has that relationship worked out? If that makes sense.
No, that's a good question. So one of the things that I appreciate that you asked that, because it just dawned on me that I failed to kind of point this out, which is kind of important, is that for one, and I know I don't think you were necessarily referring to tribal court, but ICWA doesn't apply in tribal court, right? So the biggest piece of ICWA is that it's saying that the tribes know best what's best for them, right? And their people and their communities. So with that, tribes would be the experts on themselves and their best interests and what it takes to I guess, reach that. Therefore, then ICWA requirements wouldn't be necessary within tribal court, right? Because the tribes are already making that determination. So within state court, and when it comes to multiple tribes, that gets to be, well, I won't say it gets tricky. One of the biggest things is if the child's already enrolled, that's the tribe they'll go with. Just a quick answer to your question. When it comes to enrollment or domicile, right? So a child would be domiciled on an alternative reservation than the one the child's enrolled in. However, whoever the child's enrolled with becomes the child's tribe, as long as the tribe, you know what I mean, is able to refer or send back and declare that the child is in Minnesota. It's eligible for enrollment at a minimum, but is either an enrolled member or eligible for enrollment, and then that tribe would intervene. There are instances where there could be multiple tribes, say if a child isn't enrolled but is eligible for enrollment in more than one tribe, the tribes will have the first opportunity to determine for themselves which tribe would be best suited to intervene on that ICWA case or be the party to that ICWA case. That could differ from tribe to tribe, but common sense would dictate that the tribes will go with either whoever the family has the closest ties with, right? They'll talk about like contacts within the tribe. I don't think they'll measure degree of Indian blood, and then also if there's no disagreement, if the tribes and can't agree on which tribe will be represented, then it gets left in the hands of the court, and the court will make very technical determinations on which would entail that number of contacts with the tribe, and basically whoever the child has stronger ties with, or child or children. And if you have multiple children from different tribes, you might have multiple tribes as parties to the case for different children on that particular case. Clear as mud?
Good afternoon. This is George Gogolite. That is a really interesting question, because on a pretty weekly basis, I field maybe 7 to 10 calls from agencies around the country regarding enrollment and regarding children involved in the ICWA system. And you know, everything that Mr. Needham put, it's a beautiful presentation, by the way. Thank you so much for sharing that. But the question to that gentleman, I just had a scenario that was just like that about a month ago, where the membership was split between Fond du Lac and Leech Lake, but they lived in Grand Rapids, and Fond du Lac doesn't have a tribal court, but Leech Lake does. And so it was an issue involving not so much the custody, or not, yeah, it was the custody, but it involved the parent freely giving custody to a relative, but then wanting the child back. And then so what agency or what court had jurisdiction over this? And it was really a difficult one, because how do you refer the family in the right direction? In the absence of a tribal court, which Fond du Lac does not have, but Leech Lake does, Leech Lake did not want to take that case because the child was Fond du Lac. So the one thing that we referred, that I suggested to the family, is that they petition to Itasca County, and Itasca County has a Native American judge who is well versed in ICWA. Her name is Judge Wawasik. She used to be the tribe's chief judge at Leech Lake back in, well, gosh, I think it was 2006 to probably 2012. So she's well versed in that area too. So and I think Mr. Needham explained it very, very well. It really depends on a lot of those different variables. But like I said, here at the Minnesota Chippewa Tribe, I see this. I answer anywhere from 75 to 100 inquiries per quarter from around the country, and many of them I would say almost 99% of the inquiries that are made are not, we don't have anybody that is enrolled, nor do we have anybody that is eligible for enroll. There are a few exceptions, and usually those cases come from within the state of Minnesota, and those counties are, like he explained, are mandated to, inquire on whether they are eligible for enrollment, as well as whether they are in fact Native children. So that was an interesting question. That was I seen exactly how something like that can work, but I don't know what the outcome was, because we, after we refer them, we don't have any data, and we don't stay in touch with those individuals as well.
Thank you very much. If you don't, I see that it's after 1 o'clock. So I want to respect everybody's time, but I did see that Rosemary had a question that and we're sort of going into the area of, I think, pregnancy and those sorts of issues. Rosemary, did you want to ask your question?
Yeah, I have heard multiple different interpretations of mandated reporter requirements for people who are pregnant and using different kinds of drugs. This is a particular concern when I am treating people with buprenorphine. And I think a lot of us find it to be a really morally challenging position to be in, and would like to find a way to not always have to report drug use during pregnancy. So I'm wondering if you have any guidance around that or resources that you could point us to for reference later.
That's a really tough question. I don't think that my expertise in it go that far. Some of the things that I would consider in that question, one is, like where does that definition, if it's in Minnesota under state statute, where does the definition of child start and you know what I mean, end or whatever. What are the ages? If Minnesota, so like I said, I'm not familiar with the law at the moment. I should definitely research it now. It's a good question, but if Minnesota determines that a child in utero is considered a child, then essentially then the law says if you suspect that a child is being neglected or abused. I don't know. I guess I'm not sure how that works.
We've had, of course, by taking care of pregnant women, we've had to look at this a lot, Austin, and we'd be happy for your insight. In Minnesota, if a woman is using a chemical substance, they are mandated to report. If it's alcohol or marijuana, they can provide counseling within the context of their clinical setting. Then they don't have to report, but other drugs they do have to report. I think that the challenge is the challenges that then come into play is how it stops women from coming in and seeking care is basically how that plays out. And I think Dr. Grain, I know that there's a movement to change the mandated reporting around that and change the laws around the mandated reporting around that in Minnesota. Minnesota is one of the few states that require clinicians to report women who are using during their pregnancy. And there is some movement to, I think Cresta Jones is working on it along with some other providers, and to change the legislation around that so that providers are not required to report. But Rosemary, I'm happy. I mean, I've thought about this a fair amount, as I'm sure a lot of you have, and it can be a whole long discussion. I'm happy to chat with you about that, Rosemary, sometime if you would like.
And I'd be willing to sit down there too to see if there's anything I can.
Yeah, I would love to pull you in on this, Austin, because it's not something we have connected about, and it's something that takes a lot of our mental energy.
I think one of the things we've talked about here is, doing like UTOXs on pregnant patients.
We don't do them.
Also, like if somebody does want to start Suboxone, there's, I think, ways to ask questions to get the information that you need without having the mom say, I last used heroin at this time, right? You can maybe just kind of change the way you approach the things that you need to find out.
Right. And we've also talked about, we've sort of if a patient calls and they want to talk anonymously about it and sort of get information before they come in for care, then they can call our nurse line and have us talk through what it means to be reported and what that means. And with programs like Project Child and Mothers First in Ramsey County, they have until 32 weeks to get get into treatment, to get a plan, things like that, and then they can usually navigate it so that they can go home with their baby. I know that's a whole lot of garbled information there, but yeah.
And so like I had mentioned earlier, is that there's not necessarily room for discretion on behalf of the reporter, but a lot of times for a mandated reporter, our source of information is the person or potential or alleged victim themselves, right? I think another thing that's worthy of suggesting is just making sure that the person, the reporter, provides the reportee, right, or the victim with enough awareness about their role as a mandated reporter that that person can make their own educated decision on how much they want and just make them knowledgeable, because you can't control the amount that that person shares with you, but that's up to them. That's their discretion.
It's a really not great position to provide care from. Okay, so any last burning questions before we wrap up for today? I think we could have had a whole lot more questions, Austin. Sorry that we ran out of time. Miigwech, everybody. We'll see you next time. Yes, thank you for Simone's presentation on the 21st. Thank you. Rosemary, did you